So where are we on vaccines from a legal standpoint affecting the workplace? The EEOC, the Equal Employment Opportunity Commission, has sort of taken the lead on this, the federal level, of explaining what are and aren't legal prohibitions, restrictions, and rights on employers and employees on this question. So while they're not the only agency or entity that might have an interest or be able to weigh in on this, they are one of the most influential ones who has in sort of a systematic way. According to the EEOC, which I know administers the employment discrimination laws at the federal level, so things like Title VII, race, age, sex, religion discrimination, and disability discrimination under the ADA, as well as some other statutes. They note, with respect to the ADA, that vaccination itself is not a medical examination. What does this mean? There are restrictions on when employers may or may not have their employees undergo a medical examination. So those do not generally apply to having your employees get vaccinated. If, for example, you wanted to actually provide vaccinations for your employees on site, that alone would not constitute submitting them to a medical examination, so you don't need to go through further analysis to determine whether that's okay, as you would for a medical examination. However, the rub on that is that the accompanying pre-screening questions that tend to be asked with vaccinations likely would be medical examinations, or at least medical inquiries. In other words, asking someone whether they have any allergies that might affect whether they can take the vaccination, or even if they've had any medical conditions recently that would be relevant to taking the vaccination. So in that situation, if you as an employer were somehow responsible for conducting that pre-screening through one of your employees, then you are wading into territory where the ADA may regulate what you can do. Supposing you probably set it up so it job related and consistent with business necessity to provide the vaccine and therefore ask the questions. The flip side of that would then be, once you get that information, it must be maintained confidential, and certainly adverse employment actions should not be made based on the information. That's one thing that EEOC has addressed. Another is that mandating proof of an employee's vaccination is not a disability-related inquiry. In other words, if you have an employee who, for whatever reason, has disclosed that they've been vaccinated, but it's necessary, or you choose to ask for confirmation of that, that is not a disability-related inquiry, which again would carry with it special consideration under the ADA. So you can do that pretty safely, as long as you don't probably discriminate between employees as to who you require it from and who you don't. The next step in that, however, is that asking why questions related to proof of vaccination could be problematic. In other words, if someone provides proof and you have reason to question it, inquiring as to where they got it or what circumstances, why they were at the hospital, stuff like that, could become a disability-related inquiry that may or may not be permissible under the circumstances. And the flip side of the analysis being that someone who says they can't prove that they've been vaccinated, or that says I have not been vaccinated, if they are asked why, then there is a substantial chance that their answer would be disability related or potentially religious related, in which case the inquiry becomes somewhat restricted based on the ADA, Title VII, or potentially another discrimination law. So imagine you ask somebody why they haven't been vaccinated, and they say that they've had some sort of medical condition that prevents them from being vaccinated. That was now a disability-related inquiry, arguably, and it may or may not have been job-related and consistent with business necessity. And even assuming it has, again, you'd have to keep that information confidential and both practically keep it confidential from people who might make decisions regarding that employee that are unrelated to the vaccine issue, and or hope that they don't somehow make decisions based on that disability related information that could lead to a disability discrimination claim. The one more huge issue that the EEOC has commented on is that of accommodations. So under the federal employment discrimination laws, employees have accommodation rights based both on disability and or religious beliefs. So most of you are probably well familiar with accommodating disabilities. Probably fewer of you, but still many of you are familiar with accommodating employees' religious beliefs. Those are the only protected categories under federal law that carry with them accommodation rights. Again, we're talking the reasonable accommodation without posing an undue hardship analysis that many of you are familiar with. If someone says, no, I have not been vaccinated and I'm not going to be vaccinated, and you're otherwise requiring similarly situated employees to be vaccinated, or it somehow affects job responsibilities or something along those lines, then it could become an issue if they say that they're not becoming vaccinated because of a medical condition or their religious beliefs. The key point on this, especially with religious beliefs, is that your ability to prove or disprove the belief is going to be difficult. Basically, the EEOC wants you to assume that if somebody says their opposition to the vaccine is based on their religious beliefs, you probably shouldn't question that further. The questions then become what accommodation is reasonable under the circumstances, which could range from you can sit at home without pay for some period of time until it's not critical to us that you've been vaccinated, perhaps in some circumstances, to you're going to continue to work, but you need to take additional precautions, work separated from other employees, have additional PPE available, or something like that.